Welcome to this Lunch and Learn webinar on contracts of employment. I am your host, Liz Burley, and I'll be talking today about contracts of employment and what they involve, some of the legalities around them, and things that you should be looking out for. This webinar is aimed at businesses, but if you're an individual interested in what's in your contract of employment, it may also be useful for you. So I'm going to kick off by thinking about what is a contract of employment. Next slide, please. So, what is a contract of employment? It is a legally binding agreement between employer and employee that sets out the terms and conditions of the relationship, the terms and conditions of employment. Now, some people may say, oh, I haven't got a contract of employment, but that isn't strictly true because a contract can be made verbally or in writing, or it can be a combination of both written and verbal. It can also include circumstances, policies, custom and practice, and behaviour of both parties. There's actually no legal requirement for it to be in writing, but most people have a written contract of employment in the modern workplace. So there are key differences between what we call a statement of particulars and a contract of employment. So by law, under the Employment Rights Act Section 1, everybody who is a worker or an employee must be given a written statement of the particulars of the main terms of their employment by day one of employment. And those particulars must be in a single document, and as I say, they must be given by the first day of starting work. Now, what should be in a written statement of particulars? Well, a long list of things. I'll just pick out some of them. Some of the obvious things are the names of the parties, the start date, and if it's for a fixed term, the end date. When continuous employment started, if that's a different date to the start of this particular employment, this job, the title and the description of the job, the rate of pay, method of calculating it, intervals when the worker is paid, weekly, monthly, etc. Hours of work, including normal hours, days of the week, whether the hours and days may be variable, and if so, how. And entitlement to time off. Typically we think about holidays and holiday pay, but also this can cover sickness, injury leave, and also other types of leave, maternity, paternity, parental leave, etc. Whether the worker is entitled to a pension or other contractual benefits, and the length of notice that either side must give to end the employment. Also, if there is any probationary period attaching to the employment, and what conditions apply during probation, and any period of compulsory training that's required by the employer. Now, I said that I'd outline the differences between this and an employment contract. Well, a written statement is just that. It's a statement of information. It's not actually a contract. And to meet the legal definition of contract, we need offer and acceptance and consideration, something passing between two parties. That's how a contract is made. An employment contract is a contract just like any other type of contract. So you need those basic fundamentals, and usually in the employment relationship, the offer is an offer of a role and pay and benefits by the employer, and the employee accepts that offer by signing a written document known as a contract, and the employee provides their labour in return for the payment and the benefits that are offered. So that's the fundamentals of the contract. But a written contract can be much broader than that and cover things that go well beyond the list of items that I've talked about in the written statement of terms that's required under law. Things like conduct, rules about workplace behaviour. It often goes into details about any bonus that might be on offer that's available to the employee. There might be more detailed provisions around termination of employment, ownership of confidential information, things like intellectual property, and also it might extend beyond the end of the employment and specify what an employee can and can't do after their employment has ended. I will come on to that in a little while. So different types of employment contracts. Well, we might think about permanent employment contracts. Those are for an indefinite period of time that can be terminated on notice. We might think of fixed term contracts that have a specified end date, where somebody is employed, for example, to carry out a project or for some particular kind of seasonal work. We might think of 0 hours contracts, and they can apply to where an employee isn't guaranteed a certain number of hours. That might be required from time to time, and so the employer wants the flexibility of giving an employee the opportunity to work when work is offered and only when it's offered. So I'm going to move on to think about different types of contractual terms now. Now, in legal speak, we have a list, just onto the next slide, please, Hamon. In legal speak, we have different terms that apply in contracts, and the main two that we can think about are express terms and implied terms. Now, remember at the start I said that an employment contract does not have to be in writing. There's no requirement for that. Express terms are simply those things which are agreed expressly between the parties. In a written contract, we'd expect them to be included in that document, but if there is no written contract, or sometimes even when there is, there may be express terms that are agreed verbally, but they're not written down anywhere. Implied terms, on the other hand, are terms that are in contracts, not because they're written down, not because there has been a specific agreement, but because they are necessary, for example, for good business sense. Or maybe they're customary because that's the way things have been done around here for so long. Or they may be so obvious that they don't have to be written down. Now, in employment contracts, there are some very specific implied terms that are very important. They're important to both parties, and the first one is the term of mutual trust and confidence. It's sometimes referred to as a duty, and most particularly a duty on the employer not to behave so unreasonably that they destroy this relationship of trust that is fundamental to an employment relationship. So trust and confidence goes both ways. An employer can destroy it, and an employee can destroy it. And we usually think of a gross misconduct or serious misconduct as the thing that an employee would do to destroy that relationship of trust. But on the employer side, it can be behaviour, it can be a policy, it can be something deliberate, it can be something less deliberate that is either calculated or has the effect of destroying that relationship that has to exist between an employer and an employee to keep the relationship alive. So when the term of mutual trust and confidence is broken on the employer's side, that will usually mean that an employee is entitled to resign in response to that breach. And we usually think of that and refer to it as a constructive dismissal situation. Other implied duties are around behaviour of employees, and one of those implied duties is the duty of fidelity. So in every contract, there is an unspoken term that an employee must act in good faith and honestly towards the employer. This usually plays out in meaning that the employee can't carry on a competing business in their spare time, or set up a business that competes with the employer outside of their workplace. It often goes to things like confidential information, keeping safe the secrets of the business that the employee is working for, so that those secrets are not leaked outside and maybe taken by a competitor or to a competitor. And then we come on to disciplinary and grievance matters. Well, there is no implied term in any employment relationship that an employee will never misbehave themselves, but the ACAS Code of Practice on disciplinary and grievance matters does have something to say about how employers and employees will handle themselves in disciplinary situations or grievance situations. And that code of practice can be taken into account and must be taken into account in HR processes by employers, but it can also be factored in by employment tribunals when they are thinking about claims that they're faced with, such as unfair dismissal. And excuse me. And a breach of the ACAS code by employer or employee can be penalised by up to 25% increase in damages that are awarded by the tribunal if they're awarded against the employer, or a reduction of 25% against the employee of any damages they receive through the employment tribunal system. So quite an important factor there, even though it's not strictly speaking an implied term. There are also implied terms to provide a safe working environment on every employer, and that expectation is enshrined in health and safety law in the modern workplace. And there is an implied term to pay wages for work that's carried out, so an employer can't simply decide that it's not going to pay its employees if they're available and ready to work and if they have worked. Similarly, there's an expectation and a condition that an employer will provide work to an employee who they have employed. And if they don't do so, then that would be regarded in law as a fundamental breach of contract. It might also give an employee a claim for layoff or redundancy. And so we're going to move on, excuse me, to think about statutory rights. Now, these are things that are not contained in the written document that an employee signs. They're overlaid into any employment relationship by statute. That's legislation that the government makes. And the most important piece of government legislation that rules over all employment relationships in England and Wales is the Employment Rights Act of 1996. But there are other forms of legislation that govern discriminations, and they sit within the Equalities Act 2010. Now, the statutory terms and conditions that apply to all workers and employees are set out in the legislation, as I've said. Some of these can be opted out of by agreement, for example, the limits on working time, but they are very limited and not very available to opt out of. Many conditions will apply regardless of what the written contract of employment says, and a very good example of this is notice. So there are statutory minimum lengths of notice that apply, 1 week per year of employment, up to a maximum of 12 weeks. And an employer can't simply contract out of that minimum length of notice by saying notice will only ever be a week. That just simply isn't lawful. And the statutory minimum will apply if employment comes to an end, regardless of whether the contract says something less. And many other statutory rights that apply to employees are exactly the same as this: national minimum wage, protection against unlawful deduction from wages, statutory minimum levels of holiday and rest breaks, protection against unlawful discrimination, protection for whistleblowers, protection against health and safety dismissals, and the rights not to be treated less favourably if people work part-time or if they're on fixed-term contracts. So those are the sorts of statutory minimums that apply to all workers. If we think about employees in particular, there are some enhanced statutory rights that employees benefit from that are not available to this wider group of workers. They include statutory sick pay, statutory maternity pay, paternity pay, adoption pay, and leave, of course. And minimum notice periods apply particularly to employees. The protection against unfair dismissal and the right to request flexible working. These are things that are saved for employees, and also the right to receive a statutory redundancy payment if their job is made redundant. So those are a suite of statutory rights for workers and employees. Employers can't take away from them other than by agreement with the employee or the worker. And in most cases, that agreement would have to take the form of a settlement agreement or a COT3 agreement concluded through ACAS. It's not possible to write in terms that waive these rights into a simple employment contract. It's unlawful. I'm not going to linger on incorporated terms too long, but there may be in unionised environments, for example, collective agreements that sit in documents somewhere on the employer system, and they apply to all contracts of employment. They don't have to be copied into the contract of employment, but it's wise for the contract to make reference to those collective agreements. Environments that are unionised would be include, for example, the health service and the education sector. And finally, staff handbooks. Most workplaces have a staff handbook, and it's used to set out the rules and policies and procedures that apply to that workplace. Some policies will be very specific, such as rules around using annual leave, sickness absence, management of performance. Others will be much broader. There might be statements of company values, the culture, the way we operate around here. And as I've said, in unionised workplaces, collective agreements might have quite a lot to say about the procedures around managing pay and hours of work and disciplinary procedures. Employers usually will not want policies to be contractual. That is, they won't want them to become part of the contract of employment because that will mean that the employer can only depart from the policy and changes to it with the employee's agreement, because it's a contractual matter. If policies are non-contractual, and the most usually are in handbooks, that means that the employer can make changes to them without the employee's express agreement. It's very wise for employees to be told where to find policies, and for the important policies and rules that the employee is expected to follow to be referenced in their contract of employment, so that they're given that level of importance as policies. Now I'm going to come on to talk about some contractual terms in more detail. Now, the terms that I've decided to focus on here are related really to protecting the business, as well as making sure that you don't fall foul of the law. There are, of course, lots of other terms that you might cover in a written contract of employment around pay and benefits, hours of work, fixed term, 0 hours, conditions for bonuses, for example. I'm not going to touch on those here. So in this section, I've listed a number of terms that you might have in your contracts of employment or might want to consider dealing with in those contracts. The first is entitled duties of fidelity. Now, we commonly think of those as confidentiality and loyalty obligations. So it's pretty commonly understood that during employment, employees are expected to stay loyal to their employer. That means not starting a business that competes against them, not going to work for a competitor, not stealing information, not stealing other types of property belonging to the employer. And it also relates to keeping information confidential about the employer's business. So confidentiality during employment is actually an implied term, an implied duty for all employees. But very importantly, and this is sometimes misunderstood, that duty of confidentiality does not extend beyond the term of the employment. So when employment comes to an end, the employee is free to do whatever it wants with information that may be confidential and of significant value to its ex-employer. The only duty that an employee has, that can be enforced at law anyway, is a duty not to steal or misuse trade secrets belonging to its ex-employer after employment. So anything below that very high level of information is free for them to use. And trade secrets really are very narrowly defined as things that are not publicly known. They're the secrets that really drive forward the essence of the business or the organisation, the secret sauce, if you like. Now, how do employers go about protecting a wider band of information in contracts of employment? Well, it's quite simple. Have detailed confidentiality clauses that define exactly what kind of information is considered to be confidential and of significant business value, and list those types of information out, and have explicit confidentiality obligations on the employee to keep that information within the employer's confines, whether it's the place of work, the digital system, the back office, whatever systems the employee has access to for their day-to-day work. And that obligation must continue both during the period of employment and beyond it. So for an indefinite period after the employee leaves. Having explicit express confidentiality obligations like that written in a document will give good, robust protection to the business. And it would be something that the business will be able to rely on in a court of law if ever things do go wrong and they need to escalate matters. Similarly, during the employment, individuals can have to be loyal, which means they can't compete against the employer's business. But that doesn't stop them from doing so after their employment ends. And so for most employees above, so let's say a junior level, managers, senior executives, key personnel with access to employee relationships with customers, key information about customers, key relationships externally and internally inside the business. For those sorts of employees, it is wise for their contract of employment to have built into it restrictive covenants that tie their hands after they leave employment. Typically, those covenants would cover not competing with the business and not setting up a competing business, not going to work for a competitor, and not poaching customers and possibly also suppliers for a particular period of time after the employment ends. And typically that would be anything from 3 months through to 12 months, depending on the seniority and the role of the employee. Other covenants can include not taking key colleagues, members of a team, to a competing business. All of these things are designed to protect the business that they are leaving. And restrictive covenants in contracts can only go so far as to protect those legitimate business interests, and any court which is asked to grant injunctions, for example, against an employee that has broken a covenant will look very, very carefully at whether those covenants are drafted, worded, so that they go only so far as to protect the legitimate business interests of the employer. So really important to get the wording right. Now we come on to termination of employment, and we heard earlier about statutory minimum periods of notice. We know that an employer can't go below that minimum length of notice, a week per year of employment. But what about going further than the statutory minimum? Well, for most employees, their notice period written into their contract will be longer than a week. Why? Because that's a very short period of time, and most employers will want a longer period of transition, handover, and more importantly, the opportunity to recruit a replacement for that employee. And the length of notice is often matched to how long that process of recruitment would take, and also the length of time that it's going to take to not only recruit the replacement, but also embed them into the business and put them into the position that the departing employee was in terms of relationships with customers, suppliers, and the ability to deliver productively for the business. So typically, notice periods written into a contract might extend anything from a month to a junior employee, up to 3 to 6 months for a more senior manager, and even up to 6 to 12 months for a very senior executive or board member. Termination without any period of notice will be unlawful for any employee. except in one specific scenario, and that is where the employer has reason to believe that the employee has committed gross misconduct. Summary termination without notice or pay in lieu of notice will only be justified in those circumstances. So in all other circumstances, the employee is entitled to their contractual notice, or where the contractual notice is less than the statutory minimum, then they'll be entitled to their statutory minimum period of notice. Employers can lawfully terminate without the employee serving a period of notice if they opt to make a payment in lieu of that notice period. Now, most employers will want to have written into their contracts of employment the right to make a payment in lieu of notice, and a specific right to make a payment of salary only, that's basic salary, particularly where employees might have regular entitlement to overtime or shift bonuses or other types of bonuses written into their contracts. In those circumstances, employers will be well advised to limit the payment in lieu of notice to basic salary. But it's also worth noting that where there is no contractual right to pay in lieu of a notice period, any decision to make a payment in lieu will be in breach of the contractual terms and might leave the employer open to a breach of contract claim, and might also risk the enforcement of obligations that the employee owes to the employee after termination, such as ongoing confidentiality obligations and restrictive covenants. So it's well worth thinking about that, particularly for senior employees, where you have those sorts of ongoing obligations after employment ends. Make sure that you've got the right protections built into the contract to enable you to terminate employment in a way that's lawful, that won't leave you open to the risk of a breach of contract claim. And similarly, and lastly, garden leave. For key employees who have a lot of influence over the business, access to information, access to relationships that are commercially valuable, it may be wise for them to be placed on garden leave throughout part or all of their period of notice, and particularly if the notice period is long. A period of garden leave is designed to allow the employer to retain control over what that employee does before they leave. So unlike in the example of pay in lieu of notice, where employment comes to an immediate end as soon as the employee resigned or is dismissed and is paid off in return for their not serving their notice period, garden leave means that the employee will remain employed by the business throughout that period. And whilst they're employed, they will continue to owe all the implied duties of fidelity and trust and confidence to the employer, as well as contractual obligations. And the employer can designate and specify what the employee can and can't do during that notice period whilst they're on garden leave. So it may require them to stay at home, not to contact colleagues, not to contact customers, or it may require the employee to do specific things like stay in touch with their line manager, complete a handover of specific types of work, or undertake project work. So garden leave can be quite important, particularly for more senior employees, but it can also be important where, for example, an employer suspects that the employee may be departing to leave for a competitive business, and the employer wants to take steps to secure information from the employee to make sure that they can't use it after their employment ends in favour of that competing business. I'm now going to move on to some some common pitfalls to avoid when building your contracts of employment. So the first and most obvious pitfall for employers that I see quite a lot is the use of outdated or non-compliant templates. Now, lots of employers attempted to reuse contracts that they already have, or to look on the internet, Google contracts of employment, and use a free resource. And that's fine. But you must be aware that if you use a contract which is maybe even as old as a year or 2 years, because of the pace at which employment law changes, that might be out of date even within that period of time. And if you use a free resource from the internet, well, you've no control over how old that template is, when it was put together, or for what purpose. So using templates that have been put together some time ago could leave you open to a legal claim or challenge from an employee that you have not got a lawful template and that you're missing certain statutory rights, for example. Similarly to that, not updating a contract of employment once an employee is in place, perhaps they get a promotion, a pay rise, a change of role, a change of working hours, change of pay, benefits. Having up-to-date contracts that reflect the actual up-to-date position, the exact terms of employment, will make sure that you're keeping pace with changes. And as your business grows and you take on more employees, have a larger workforce, you will find that it'll be very difficult to keep track of changes in any other way than to make sure that you have an audit trail of paperwork, whether that's issuing the whole contract, reissuing the whole contract as the change happens, or recording the change, for example, if it's a small change to hours or an increase in salary, in a side letter, or even just in an email, and making sure that those documents are saved on the employee's personnel record. So updating the contracts as things change is a very important thing to do. Beyond that, making sure that the contractual terms and the obligations on the employee are appropriate for their role, and specifically their notice period and their restrictive covenants if they have them. Equally, if they don't have restrictive covenants, considering whether a change in their role to a more senior level or increased responsibilities, increased pay, might merit the introduction of restrictive covenants if they're not there already. We've looked at having the wrong non-compliant templates and outdated templates. Having the wrong type of contract can be equally dangerous. So using a fixed term contract inappropriately can cause difficulties for businesses. Using 0 hours contracts that miscategorise employees as non-employees can be dangerous for a business. So always assess whether the template that you have is appropriate for the type of role, the working arrangements, and the terms of the employment. We looked at termination provisions earlier, and if these provisions are unclear in your contract, I explained that you might believe yourself open to breach of contract claims for wrongful termination of employment, or you may have unclear or vaguely worded restrictive covenants that might not be enforceable against the employee. These things are very difficult to put right after the event, so make sure that you are regularly reviewing those provisions in your templates and they protect your business. I suggest that your contract templates are, as a matter of course, reviewed every 2 years. And if people change roles, you have specific reviews for the appropriateness of their contract templates for their new role. And finally, we'll look at some useful resources. The ACAS website is useful for all sorts of different information on employment rights. I would say that it is very pro-employee. So if you're an individual, it'll tell you what your rights are. It won't necessarily speak to businesses, but it's a good starting point. Gov.uk has some interesting pages where you can look at employment contracts and conditions and also employment status if you want to find out more about the differences between, for example, 0 hours workers and employees. And finally, we at Burley Law have put together some free resources that are available to you on our YouTube channel. Please check that out, particularly the webinars and my podcasts. And after this webinar, we're going to send you a free contracts of employment guide that will tell you a little bit more about some of the areas that we have covered today. Our upcoming Lunch and Learn schedule is on the screen now. Our next Lunch and Learn will be on the 10th of April. We'll be thinking about all things probationary periods. It's a really important topic, and managing probationary periods is going to get much more complex and much more important as we move forward through 2025, and we find out more about what's in store in the Employment Rights Bill. And thank you for attending today. And I've been your host, Liz Burley, and I look forward to seeing you soon on a future Lunch and Learn webinar.